Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair.
Another threat. Wow.
You're probably going to hear more than one. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn and I'll continue to up the ante. I don't give a shit if you object. Is it clear what I said? I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay? That's just the way it works. My courtroom, I get to decide how it's run. Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two
Have you ever had a grilled cheese?
Other issues as well.
You're in contempt of court. Put him in jail.
Hey everyone. Today, we're looking at one of the most stubborn sovereign citizens we've ever seen on this channel. This guy refuses to answer any questions and acts like the law doesn't apply to him, even when faced with one of the sharpest judges on YouTube, Judge Oakley. It's fascinating to see how he tries to talk in circles, but Judge Oakley stays calm and in control, handling the situation like a pro. What do you think? Did Judge Oakley handle this well, or should he have been stricter? Rate his performance from 1 to 10 in the comments. Now let's dive into one of the most intense court hearings I've ever watched.
You're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You have.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights as I come.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceedings?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, he's, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, you know, pending Your Honor's ruling on that jurisdictional issue, I have prepared for to conduct a preliminary exam.
Okay.
And could be, you know, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today,
Do you have a jurisdictional argument you want to make?
what I've served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes
multiple
or
arguments.
no?
You know, this right here is the biggest issue with sovereign citizens. They twist courtroom rules like they're starring in some low-budget legal drama. It's frustrating and honestly feels so dishonest. That's why so many people, myself included, can't stand this behavior. Now, just to be clear, I'm not a sovereign citizen, but if I were, I'd at least try to show some basic respect in court. Otherwise, you're just asking for a contempt charge. I'm not saying they're the worst people in the world, but come on. If they could just tone it down and show the judge a little respect, maybe they'd get treated with a bit more dignity. And, seriously, what's with refusing to answer simple questions? I get that they have an ego thing, but dodging basic questions isn't going to make or break their case. It just makes them look ridiculous.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work
criminal
under the authority
or
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is
And
it?
it's not common law.
Which
it's
one?
statutory.
Okay, so it's statutory, that is what, civil?
No.
So what is it? For the
My
record, I need to
jurisdiction
have
is
it
both
on-
civil-
I can't defend myself unless I have it on the record. Is it,
My
it's
jurisdiction.
only two?
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my
Constitution.
ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
electi.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party.
All right, so this guy is out. Here claiming there has to be an injured party for his criminal case. Like, seriously? Where's his logic? On vacation. Let's break it down. In the real world, an injured party isn't just someone limping into court yelling, "He got me." In cases like this, the state itself is the injured party. Why? Because breaking the law affects everyone. That's exactly why the judge made it clear. The injured party is the people of Michigan. You can't just ignore laws and say, well, no one's bleeding, so I must be in the clear. That's like robbing a bank and arguing you're innocent because the vault didn't personally file a complaint. What do you guys think? Is this guy really this clueless? Or is he just here to waste everyone's time? Let's jump back in and see if he can outdo his own nonsense.
Who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right, and would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt, and we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom, and I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness, yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611B, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of probable cause conference, and I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause. This is a preliminary exam. This is okay. So right here,
this is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
This right here is why I respect this judge so much. He knows exactly how to handle sovereign citizens. He doesn't let them take over the courtroom with their nonsense, and he's not afraid to shut them down when they try twisting the law to fit their wild ideas. I know some of you in the comments yesterday were saying he's too harsh, but honestly, I couldn't disagree more. We need this kind of attitude. These sovereign citizens act like the laws don't apply to them, and sometimes a little firmness, or even sarcasm, is exactly what it takes to put them in their place. What do you guys think? Is the judge being too tough? If so, explain why. Because from where I'm sitting, he's just doing his job. This guy is wasting tons of taxpayer money, and the judge calling him out, or even fining him, is completely justified. I mean, what's the alternative? Just let these people turn the courtroom into a circus? Yeah, no thanks. All right, let's jump back in. Something tells me this sovereign citizen is about to rack up another fine, or worse.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing, and that I did not.
They're the same thing, Mr. Michaud.
On this,
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever
columns?
had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? If it's a hearing, or
you didn't
right.
waive it.
So
There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC.
Cool, man. I really wish we could see this guy's face right now because the amount of time wasted on him trying to grasp the most basic concepts, like a probable cause conference, is beyond frustrating. It's not rocket science. It's literally just a discussion to determine if there's enough evidence to move forward. But nope, this guy is acting like he's prepping for the bar exam or something. And don't even get me started on the grilled cheese moment. That actually had me laughing. The judge was probably sitting there thinking, how do I explain this to someone with an IQ of 12? And finally just settled on grilled cheese like, all right, maybe this will get through to him. What do you guys think? Is he actually this clueless? Or is he just pretending to be dumb to weasel his way out of this? Personally, I think it's a mix of both. He probably thinks he's being some kind of genius, but in reality, he looks like the dumbest person on the planet right now. All right, let's jump back in because this is about to get wild.
Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, you've ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I want like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
criminal what?
Bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
okay, listen. You can't tell me something and then just disagree with me and think. Listen to me, sir. I am not going to let you interrupt me.
No, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom. I get to decide how it's run.
This court hearing should have been over at least 10 minutes ago, but nope. Here we are, watching this sovereign citizen drag it out like it's his personal TED Talk. It's honestly wild how they walk into court acting like the judge is their personal legal assistant, demanding explanations for things they should already know, or that their lawyer could have easily told them. At this point, I have to wonder, is this just stubbornness, or is there something deeper going on? Because it really feels like these people have a serious mental block when it comes to understanding basic courtroom rules. Judge Oakley is doing his best to keep things on track, but if he can't get them to follow simple procedures, I don't know what will. Maybe more warnings? Honestly, if this guy interrupts again, a night in jail might be exactly the wake-up call he needs. What do you guys think? Is it time for the judge to lay down the hammer? Let's dive back in and see if this guy finally gets it together, or if he's about to spend the night behind bars.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice. Okay. Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't recognize any of that.
United States citizen. I am actually
hold on, stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you and nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean, hold on. It should mean something. Because
prove it. Please prove it.
Can I prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank Michaud.
I have full faith and credit.
I can prove.
Okay, so
hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here. And you proved it for me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
Okay.
But you still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
listen to me, Mr. Michaud.
You have.
I've wasted too much time with you. Yes or no?
So,
sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
Boom. Just like that. 30 days in jail. If that's not a wake-up call for every sovereign citizen out there, I don't know what is. If you're stepping into Judge Oakley's courtroom, maybe, just maybe, rethink your life choices and hire a lawyer. And honestly, it doesn't even have to be a good lawyer. Just anyone who actually knows what they're doing would be better than walking in thinking you're some kind of legal mastermind. This guy really thought he could run the show, making demands during a probable cause conference like he was in charge. All he had to do was answer a few basic questions, and he could have gone home. But nope, in his brilliant little mind, he figured he could outsmart the legal system by talking in circles and confusing the judge. Spoiler alert, it did not work. Favorite part? When Judge Oakley broke it all the way down at the end, he literally said, "You showed up when I called your name. How much more obvious can it get? Like, come on." This guy really thought he could dodge reality with word games, and now that ego trip landed him right in a jail cell. And honestly, I don't feel bad at all. The law isn't a suggestion, and judges like Oakley aren't here to play games, so what do you guys think? Was the judge too harsh, like some people said in the comments on my last video? Or was he completely fair? Personally, I think he handled it perfectly, but I'd love to hear your thoughts. And hey, if you enjoyed this video and want more like it, don't forget to like and subscribe. It really helps the channel, and I appreciate every single one of you for watching. Thanks so much. Take care, everyone.